We'll go live at 4 exact, or
we can start anytime. I am ready. From my side, there is no hitch at all. 4 o'clock is also fine.
Yeah. Namaskaram, everyone. And on behalf of Indian Academy of Pediatrics, the Telangana State Branch PATS, and the group of F3, I welcome you all for today's very exclusive special webinar. At the outset, let me thank the office bearers of IAP Telangana State for giving us this opportunity to share the wisdom of pediatricians, doctors specialized in finance across the country for sharing their valuable advice with us once every fortnight. And our immense thanks to all the viewers for actively participating in discussions, not just during the live session, but also in recorded sessions later on. The motto of this is to ensure all the doctors have the required knowledge to make wise decisions when it comes to finances. And today's topic is extremely special. Very few of us have a good understanding of indemnity insurance. Many of the times when you go to a new employment, that is when you realize that the new employer is asking you for an indemnity insurance. And that is when most of us wake up and realize the importance of it and try to search for the exact information on it. To introduce the speaker and also the topic, I now hand it over to Dr. Rajesh to take the session forwards. All the attendees will be on mute through the session, but please feel free to share your thoughts, opinions as well, along with queries in the chat box. Dr. Rajesh will compile them and put it up as questions to the speaker and also share his wisdom towards the end of the session. The session will be for about 45 minutes, and I seek the cooperation of all the attendees now. I'll hand it over to Dr. Rajesh. Over to you, Dr. Rajesh.
thank you, Dr. Sri Krishna sir. And it's a great pleasure to welcome Dr. Nilesh here. He is deeply researched this indemnity insurance. It's his favorite topic, I think, now. And he's spoken at multiple platforms about indemnity insurance. And I met Dr. Nilesh very recently at a function of IMA Belgaum, where he was a co-speaker. And everybody there learned so much about indemnity insurance from him that we thought that this should spread to every doctor we know. So he very kindly has agreed to come on this platform of IIP PATS and share his wisdom about the indemnity insurance. Now, indemnity insurance is something that every doctor has to have in this age because of so much rise in medical legal cases and so many cases being filed against doctors, and especially because of the Consumer Protection Act. We all know that we are under Consumer Protection Act, and even the district level, you can ask for a compensation of 1 crore now. So the amounts at stake are huge, and I think it is very important to know all angles of indemnity insurance. It is just not enough to take a policy from anybody for say 1 crore or 2 crore and say I am covered. There are many clauses and many sub clauses, and there are many terms and conditions in the indemnity insurance that we ought to know. So to clarify all this, Dr. Nilesh Nafde is here. He is an anesthetist and a radiologist by profession. So after his anesthesia, he did radiology also, and he enjoys, both the fields. He really enjoys practicing, and we really look forward to hearing your words of wisdom, sir. So, Dr. Nilesh Nafde, the stage is all yours.
Thank you very much. Thank you very much for the kind introduction. Thank you very much for having me here on this platform. And my entire intent in this whole session is going to be enlightening the listeners. Those who are totally uninitiated, they should understand as much more about indemnity as possible. Those who already know some bits about indemnity should go a few steps ahead. That is the whole intent. So anything I repeat a couple of times or something should be construed purely as an intent of driving home the point or stressing on that point entirely. as Dr. Rajesh sir said, this is not my favorite topic. I have a lot many more favorite topics. This is a topic suddenly which has become a favorite of the listeners. That is why I am being called everywhere to speak only on this topic. There are a number of other topics also which are primarily medical legal or para-academic in nature, but for reasons best known to the listeners, this topic has been become a hot topic right now, and I'm being called everywhere. Wherever I'm, they ask me to speak only and only on indemnity. So that is how it appears that this is my favorite topic. So may I, with the permission of the organizers and everybody and the listeners, may I share my screen and start with the presentation?
Please go ahead, sir.
Yeah. Is my screen visible to everybody?
Yes, go ahead.
Okay. So now let us have as much as possible in these next 45 minutes, which will empower all of us to have a 360 degrees view of what indemnity insurance exactly means. What are the pitfalls? What are the nuances and nitty-gritties of an indemnity insurance? Each one of us needs to know in requisite detail is everything about an indemnity insurance, which we all have. Now, because this is a webinar, I am aware that I will not be able to elicit responses from the crowd, nor I be able to see people agreeing, disagreeing, or frowning over me, which I usually enjoy in a physical academy, in a physical conference or a CNE. But the corollary is that I will not be able to ask any questions to people and elicit responses. But at the same time, I almost know what the responses of the people will be. Let us start with the first term of indemnity. Now, when we say life insurance, when I talk of health insurance or any other vehicle insurance, general insurance, the other terms associated with the word insurance are known to us. We use them in so many other walks of life, except for the word indemnity. In indemnity insurance, the word indemnity was first occurred, or first I confronted this word when I first ever purchased an indemnity insurance as a professional. So we all need to understand the very simple English meaning of the word indemnity. A promise to pay somebody an amount of money if he or she suffers any damage or loss is the simple English meaning of the word indemnity. Or in Hindi, it can be worded as क्षति की पूर्ति के रूप में धन देने की वचनबद्धता. I will like to underline here that underline the words if. A promise to pay. A promise means there is no payment beforehand, and it's only a promise. And the promise is fulfilled if there is any damage or loss. So a person who has an indemnity insurance is said to have been indemnified. All these words and terms I'm going to introduce in the course of my talk, because we all need to be familiar, well-versed, and comfortable with the words associated with an indemnity insurance policy, with the words which you will all encounter as and when or whenever you have to avail of an indemnity insurance, or you have to search for your papers. And at that time, these words should not sound bombastic or foreign to any of us, any one of us. Hence, I will like to explain. I've just told you what is indemnity, and I have also told you that a person who has an indemnity insurance is said to have been indemnified. What is that person indemnified against? The person, or in our case, a doctor, is indemnified against claims of compensation. Indemnified means immunized. So we are immunized, protected against losses due to compensation claims. That is what indemnity precisely means. So why are we discussing indemnity in such details? There are 5 reasons. The Consumer Protection Act was applied to the doctors in 1995. That has made patients more aggressive. These kind of scenes and appearances are very common in every hospital and clinic. Too many agencies have the powers to show us the red card. I have just enumerated 6 here. All of these agencies which you are seeing on the screen have the powers to issue a notice, which I call a red card, to a doctor. Numerous insurance companies have introduced indemnity policies. Almost every brand that you are seeing on the screen now has an indemnity policy to offer. Hence, it is very heavily marketed. And the last, courts and commissions have pronounced dreadful judgments against doctors in the past few years. Does anybody here know the largest amount of compensation ever awarded against a doctor in the Indian courts. Do you know what the volume of that compensation was? The answer is it was a whopping 12 crore rupees compensation. An Indian doctor has been slapped a compensation of 12 crores by an Indian court. The fact, the fine details of this case are that the compensation was actually 6 crores, but due to the simple passage of time and the accrued interest on the 6 crores, the doctor had to cough out 12 crore rupees compensation for the patient. That is all that makes a compensation claim really dreadful, and that is all the only reason why we all are discussing indemnity so many times and in so many details. Now, in these reigning compensation claims on all specialties and all doctors of the subcontinent, indemnity is the only umbrella that can protect you against these claims. And that is why indemnity policy has to be purchased, and it also has to be understood in all its details by each one of us. Every doctor loves to have this picture about himself in his life. A happy-go-lucky, pleasant, contented doctor who is economically, financially, socially stable and contented in all spheres of life. But one striking indemnity claim has the capability of converting this doctor into a pauper with empty pockets and the most miserable, unhappy person on earth. Whenever you receive a legal notice or court summons, or whenever you go through a litigation, please try to understand receiving a legal notice or a court summons is much different than actually going through a litigation. That's why I have categorized them as separately. But still, whenever you receive a legal notice or you have to go through a litigation, you go through 7 losses, 7 assaults or 7 harassments. There is a dip in self-esteem. There is an embarrassment, social as well as personal. There is emotional stress. There is a social gossip. People talk about you and the goof up and the litigation and the notice that you have received. There is peer harassment. Your own peers start talking about you in whispers which can be heard. And also there is a tremendous component of self-blame. Had I not done this, this would not have happened. Why the hell did I give this drug to the patient? Why the hell did I take this step instead of doing X, Y, Z? These issues plague your psyche and you are absolutely harassed. But these are 6 issues. Nothing can protect you from these 6 except a good friend or a good professional association. In your case, I suppose it is the IAP. In my case, because I'm an anesthesiologist, I consider ISA or an IMA for all of us. A good professional association and good friends can help you bail out yourself from these 6. But the 7th, that is financial losses, also there is something else that can protect you from all this, and that is indemnity insurance, which protects you against financial losses. Indemnity insurance is a hedge against a potential risk. What is the English meaning of the word hedge? A bush or a tuft of a group of trees behind which you hide. So a hedge, hedge fund, you are all people who are financially very wise. So you should be understanding and knowing what is a hedge fund. Indemnity is a hedge which protects you against the potential risk. Now, there are so many words about an indemnity insurance, which I am going to elaborate and which I feel most of us may not know. I will first enumerate those terms which are very routine and native in an indemnity world. I call those words as the indemnity jargon. Those words are indemnitor, indemnity, retroactive date, AOA, AOY ratio, claims made basis, occurrence basis, nose coverage, tail coverage, and runoff cover. These are all different terms which are only and only associated with an indemnity insurance policy. All of those here who have an indemnity policy, but who don't know any or many of these terms, are nothing different than this man, because you all have an indemnity policy, but you don't know these words which are associated with indemnity, which are principles of indemnity. So, like him, only you are the ones who feel that you are covered by the indemnity, when actually you may not be covered because you have an indemnity, but when you know nothing about it. So let us start the journey of understanding the indemnity policy and indemnity features better. First, I will explain to you the term indemnity. Try to understand this is different from indemnity. Why indemnity? A person or a doctor or organization held harmless in a contract is called an indemnity. I hope this is clear. I don't need to explain this further. An indemnitor, the party, most often the insurance company, which holds harmless a person or an organization in an indemnity contract is called as an indemnitor. So in your and my story, friends, we or you as a doctor are the indemnity, and the insurance company from which you buy the indemnity policy is the indemnitor. Should I move ahead? So please note the difference, friends, between the words indemnity and indemnity. The first indemnity is the policy that you possess, and you are the indemnity, like nominee. So I hope there is a clarity on the terms indemnity, indemnity, indemnitor, indemnify, and indemnification. Now we will go to the next term, which I would like to explain everybody. What is limit of indemnity? The sum for which you are insured in an indemnity policy is called as the limit of indemnity. Like every life insurance policy has a limit, health insurance policy has a limit. So the indemnity policy also has a limit. The sum for which you are insured in an indemnity policy is the limit of indemnity. Now, the other terms which I can use to explain the limit of indemnity is maximum policy amount in an indemnity policy is the limit of indemnity. But friends, within that limit of indemnity, there are two more limits I would like to explain to all of you. First is the AOY limit, and the second is the AOA limit. What is the AOY limit? Total limit of the indemnity policy per year. So AOY stands for any 1 year, any 1 year. So AOY limit is the total limit of the indemnity policy per year, whereas AOA is any one accident. That is another limit. So first limit is AOY limit, and the second is any one accident limit. The maximum sum you want to be paid per accident. Now, I hope these words are quite self-explanatory. You should all be able to understand. The total limit of indemnity policy, I will explain to you. Suppose now you have a 1 crore rupees policy. So the AOY limit in your policy is 1 crore. Total limit of the indemnity policy per year is 1 crore. But the maximum sum you want to be paid per accident in that year may not be 1 crore. If you, while buying a policy, say that I want 2 accidents to be covered in 1 year, then your AOA is 2. So you want 2 accidents to be covered in 1 year. So though your annual limit for any 1 year is 1 crore, you have conceded or accepted with the company that for 1 accident, I want only 50 lakhs out of that 1 crore to be paid as compensation, and I want the remaining second half of 50 lakhs to be reserved for the second accident which I am likely to face in that same year. Am I right? Am I clear? Any 1 year is the limit for that year, and any 1 accident is the number of accidents you want to be covered in every year. That is called AOA and AOY limit. Now you have a 1 crore rupees indemnity policy. You believe that any compensation below 1 crore will be met by your indemnity insurance. Am I right? Everybody believes that. Agar mere paas 1 crore ki policy hai, and if I am slapped a compensation of 60 lakhs by the court, so obviously that 60 lakhs will be paid by the insurance company. Presuming this to be true, when you are slapped a compensation by a court, you make a claim to the insurance company. But what happens is your insurance claim denied. Your indemnity is denied. And then you don't know why it has been denied. There is a big question mark before you that when I have a 1 crore rupees policy, the court has asked for a compensation of 50 lakhs. Why the insurance company is not honoring it? This gives rise to last minute distress. Because you have not studied the indemnity concepts well, that is why this happens. After today, you will never have this kind of a confusion. There is something called as validity of an indemnity policy. Now, what is the validity of the indemnity policy? For every individual who is listening to me right now, I am sure that person believes that the validity is temporal validity, that is validity in terms of time. I have bought a policy for 1 year from 1st January to 31st December. So my policy is valid from 1st January to 31st December. This is the only meaning of validity most of the doctors, I believe, must be imagining. So they feel that validity in terms of time is the only validity. The answer is no. There are a few more validities associated besides temporal validity, which I shall elaborate now. In order to understand the validity of an insurance policy, I'm going to use the picture of this pig. The first arrow that has come down in front of you right now, on your left-hand side, is the time when you have bought the policy. The first arrow is the time when you have bought the policy. And the second arrow which has come down in front of your eyes is when the policy has ended. So it's a 1-year policy. The first arrow is at the first day of the year, and the second arrow is the last day of the year, which means that between the arrows is the main part of your policy when you are covered and the policy is active. What is on the prior to the arrow, prior to purchase of the policy is called as the nose area, and what is after the policy ends is called as the tail area. Am I clear on this? Should I go ahead? Because we are going to use the nose and tail very often in the subsequent discussion. I'll tell you an example. You have a friend, a doctor who has started practice 8 months ago. Friends, I know that many of us are going to be pediatricians. Pardon me for this, but I am an anesthesiologist. My examples are likely to be associated with an anesthesiologist. So you can always extrapolate it to pediatric practice or something. But I'm just trying to use my own example of my own people, my own friends, to explain to you certain concepts. So you have a friend who has started his practice 8 months ago, young budding anesthesiologist. Somebody tells him about an indemnity insurance. He decides to buy a policy. So when he is told 8 months after he is into practice, he takes 3-4 months to make up his mind, and he decides to buy a policy when he is 1 year into practice. 1 year old in practice, and he comes and says, now I want to buy a policy. Can this doctor be indemnified for the bygone year of practice? 1 year of practice is over. He is buying a policy. Can he be covered for the acts in the past year? In other words, can the period before buying a policy be covered in the proposed policy? I am sure most of the people's answer is no. But the facts are contrary. They can be covered. This is precisely what I want all of us to understand. If you have sons, daughters, daughter-in-laws, son-in-laws who are entering into practice, you can always ask them to buy a policy which is backdated. I mean, which has a retrospective effect. What is that called? That is called as nose coverage. So area before the first arrow is the nose coverage. So if a policy covers a period before the first arrow on the pig, before you bought the policy, it is called nose coverage. The feature in an indemnity policy that covers professional acts prior to the purchase of the policy is called as nose coverage. Am I clear? Now the issue is, what we need to understand is that they will ask you to give them a undertaking that you have not received a single legal notice in that 1 year. You have not received a single police complaint or a police summons or a court summons or a consumer court summons in the bygone 1 year. Presuming that until the time you purchase the policy, you are unaware of any possible claim for cases during that period, you are given this nose coverage. Otherwise, or else you will not be given this nose coverage also. But if you are sure that there is nobody trying to sue you for the period in that 1 year, you can always protect yourself for acts in that 1 year by the purchase of a nose coverage. Now, how much prior to the purchase of the policy, how much period is covered is stipulated in the policy document. So it can be 3 months, 6 months, 9 months, 1 year, anything. You will have to pay according to the period you want to cover yourself. The extent of the nose coverage will determine how much extra to pay for the nose coverage. I hope I am clear on this nose coverage. So what we just saw was you buy at the first arrow, you buy the policy, and the main part of the policy begins at the arrow, the policy ends. But you can buy the period before the first arrow. That is called as nose coverage. Now let us go to understand what is tail coverage. You can almost extrapolate from nose coverage what is tail coverage. The feature in an indemnity policy that covers professional acts even after the policy is discontinued, policy is cancelled, or policy shifted to some other company. If your policy covers those acts after that policy has ended, then the policy is said to have what is called a tail coverage. After the policy has discontinued, if it covers your acts of negligence, then that policy is said to have a tail coverage. Am I clear? Now that we have understood nose coverage and tail coverage, I will go to explain two new terms. These are two other terms which classify indemnity policies into two broad categories. First is occurrence-based policies, and the second is claims-made policies. Let us first talk about occurrence-based policies. The name is quite self-explanatory. These are policies which cover incidents that occur when policy is in force, irrespective of when the claim is made or when the case is filed. So, again, in order to elucidate this further, January to December, you have a policy, and an incident occurs in the month of September. December, your policy ends. February, a patient goes to the court. Still, this policy was in force in September when the case happened, when the occurrence took place. If the policy covers that incident, it is called occurrence-based policy. Even if the tenure is over, the policy has been cancelled, the claims are honored if the incident has occurred when the policy was in force. They are also called as long tail policies. Is that right? Second arrow ho chuka hai. Second arrow is over. Your policy is concluded. The policy tenure is over. Then a notice has come. Then a case has been filed for an incident before the second arrow, between the first and the second arrow. But the policy is still valid because it is called occurrence-based policy. So this policy is supposed to have a long tail feature. Am I right? Again, I am trying to show you this picture because I want to tell you, when you buy a coverage before the first arrow, it's no coverage. And if it is an occurrence-based policy, it covers your acts during the main part of the policy, even after the policy is discontinued. So it's called a long tail policy. Now we just saw what is occurrence-based policy. Now let us go to what is claims-made policies. What are claims-made indemnity policies? These are policies which are required to be in force when the incident occurs, as well as when the claim is made or the complaint is filed. Iska matlab kya hai? When the incident occurred, the policy has to be in force. But like the previous example, when the complaint is made, if the policy is not in force, then a claims-made policy will not settle your claim. Because the claims-made variety of policy requires that the policy has to be in force when the incident occurs as well as when the complaint is made. So there is no nose coverage, there is no tail coverage in a claims-made policy. At any given time, the policy has to be in force. Only then a claims-made policy is valid. So I am explaining to you how the validity changes between two types of policies for the same tenure and maybe for the same sum assured. So in a claims-made policy, there is no nose coverage, there is no tail coverage. So one main part of the policy has to be in connection with the second main body of the policy. So main body connected to main body, linked to main body, followed by main body. There is no nose and there is no tail coverage. This is what a claims-made policy is. Okay. So now coming to AOA and AOY ratio in terms of validity. I have just told you AOA is any one accident and AOY is any 1 year. Now I will like to explain with an example how AOA-AOY ratio affects and effects your indemnity claims and indemnity policies, your validity of indemnity policy as well. Indemnity policy of 1 crore. Now we will go by an example. I will speak in terms of you so that you understand. Let us presume that you have an indemnity policy of 1 crore. Now we are going to stick to this example of you having an indemnity policy of 1 crore. You have been slapped a 1 crore compensation by a court. You have a 1 crore policy, compensation awarded is 1 crore. If your policy has an AOA-AOY ratio of 1:1, then the 1 crore compensation awarded by the court will be paid by the insurance company. Very, very clear? I'm moving ahead. This is a problem of webinar because I just don't understand what people, whether they agree, whether they understood, should I go ahead or no? Presuming that I am clear on this, I am moving ahead. For the same example, you have an indemnity policy of 1 crore, you have been slapped a compensation of 1 crore by the court, and you have a policy with an AOA-AOY ratio of 1:2. So only 50 lakhs will be paid by the insurance company. Why? Because out of the 1 crore, you have chosen a number of 2 accidents to be covered in 1 year. So you have asked the insurance company that out of my 1 crore, give me 50 lakhs for 1 accident and reserve 50 lakhs for the second hypothetical accident which is likely to happen in that year. So even if your policy is of 1 crore and you seek 1 crore compensation from the insurance company because the court has slapped you with a compensation of 1 crore, the company will still pay only 50 lakhs because your AOA, AOY is 1:2. Now, if you have an AOA, AOY of 1:4, again, same example. You have an indemnity of 1 crore policy. You have received a compensation award. You have been asked to give a compensation of 1 crore by the court, and your AOA, AOY ratio is 1:4. So how much does the insurance company pay? 25 lakhs, because 4 accidents in 1 crore. 25 lakhs. You will have to foot 75 lakhs. Am I clear? Now we will move forward. In the same year as this case, you have a 1 crore rupees policy. You had been slapped a 1 crore compensation, and this is how the compensation claim will be settled depending on your AOA, AOY ratio. In the same year, another compensation is slapped against you by the court. You have been slapped a second order of 50 lakh rupees compensation. What was the first example? 1 crore compensation. Same year. So you have a 1 crore rupees policy. Now, if your AOA, AOY ratio is 1:1, then what happens? In the previous case, the insurance company has already paid 1 crore compensation. So now, the second order of 50 lakhs, who will pay? The answer is you. Because you had 1 crore indemnity policy and you had 1:1 AOA, AOY. पहली केस में इंश्योरेंस कंपनी आपकी ऑन योर बिहाफ 1 करोड़ रुपया भर चुकी है, पेशेंट को दे चुकी है. तो ऑब्वियसली द सेकंड क्लेम ऑफ 50 lakhs, you will have to foot the cost. Now, if you have an AOA, AOY ratio of 1:2 and the second compensation of 50 lakhs has been presented to you by the court. Past case, insurance company had paid 50 lakhs in the first case. Now again the company has a provision of paying 50 lakhs and the compensation awarded is 50 lakhs. So the second claim of 50 lakhs, who will pay? Answer is insurance company. Am I clear? So you should know what kind of policy to buy so that you are always immunized against compensations slapped on your face by the court. In this example, if your AOA, AOY ratio is 1:4, the first time, because it is 1:4, the insurance company had paid 25 lakhs for the compensation and you had paid 75 lakhs in the first claim. Now the second claim of 50 lakhs, what will happen? Again, insurance company will pay 25 lakhs and you will pay 25 lakhs. So in both the examples, you had to pay because your AOA, AOY ratio was 1:4 and you had a policy of 1 crore. Am I clear? Now, AOA, AOY ratio of 1:5 or 1:6 is not available in India. Probably the Indian government or the IRDA or the insurance companies believe that if you feel that you can face 6 compensation or negligence claims against you, it's best you stop practice. Because 6 compensation claims per year is a strike rate of 2 compensation or negligence cases against you. 1 case against you every 2 months. So the answer is, that is why probably India does not offer, Indian insurance companies don't offer an AOA, AOY ratio of more 5 and 6. Maximum is 1:4. Now another example. Or rather, I will use another example to explain to you the validity concept of an insurance policy besides temporal validity. This is particularly applicable to the senior doctors amongst us, or maybe our parents if your father or mother is a doctor. Now, you stop practicing June 2023. Again, this is an example, an imaginary example I am going to explain. You stop practicing June 2023. You start enjoying a retired life. Since you have stopped practice, you don't extend your indemnity policy. So you have stopped practice, you have stopped your indemnity policy. 8 months later, you receive a notice for a case you did in May. That is 1 month before you retired. For the month of May, there was a case which you did in May 23. You receive a notice. Yours is a claims-made policy. Friend, what was claims made? Policy has to be enforced when the claim is made as well as when the event occurred. So you have a claims made policy. So what happens? Your indemnity policy is invalid because you have discontinued the policy. 8 months later, you have received a claim for an event that occurred when the policy was in force. But today the policy is not in force. Your policy is a claims made type policy. So your insurance policy is invalid for this claim. Now let us presume the same story. You receive a claim for an event in May 23. You have retired in June 23. 8 months later, you receive a claim. But your policy was an occurrence-based policy. What is an occurrence-based policy? जब घटना घटी तब यदि आपकी पॉलिसी फोर्स में है, whenever the incident occurred, if your policy is in force, then irrespective of when the claim is made, when the case is filed, your policy will be honored. In this case, it is the case is filed 8 months after you stop the policy, but it is occurrence-based policy, so your indemnity policy is currently inactive but valid. Am I clear? Two examples of valid and invalid insurance policies, indemnity policies, beyond the domain of temporal validity. This is what I'm trying to explain to everybody, that you need your policy to be valid in very many senses besides just time. Now, for this example, when you stop practice and then 8 months later you receive a claim, you need to know another concept in an indemnity policy which is called run-off cover. What is run-off cover? Run-off cover, if you want to stop medical practice, you have a claims made policy. तो occurrence based को छोड़ दो, भूल जाओ, because that is a good policy. Occurrence based तो कभी भी claim आएगा तो settle करने वाला है. But you have a claims made policy. Therefore, a valid indemnity cover, even after stopping practice, what you need to purchase from the insurance company, when you stop practice, you need to purchase what is called run-off cover. If anybody out of the listeners has not understood, I will just repeat it. Pardon me for those friends who have understood. Please pardon me for repeating it. You are stopping practice. You don't want the indemnity, but you want, and you have a claims made policy. So when you stop practice, you want yourself to be covered for acts of negligence before you stop practice. Acts of negligence before you stop practice. For claims made on acts of negligence after you stop practice. प्रैक्टिस बंद करने के बाद आपके ऊपर आने वाले क्लेम्स से आपको छुटकारा चाहिए उन घटनाओं के लिए जो आपने प्रैक्टिस से पहले की हैं, उन केसेस के लिए जो आपने प्रैक्टिस बंद करने से पहले की हैं, तो आपको खरीदना है व्हाट इज कॉल्ड रन ऑफ कवर. So that if somebody says you were negligent and you feel that, oh, I have retired, but if you have a run off cover, then it's an extension of an indemnity insurance, because it continues to protect you, or it continues to offer you a cover for allegations of professional negligence after you are no longer in practice or have retired. Now, this run-off cover can be purchased for 1 year, 2 years, 3 years, 4 years, 5 years, any period of time. Most frequently, the insurance companies sell this run-off cover for a lesser premium than an active policy. 3 साल के run-off cover के लिए 1 साल का प्रीमियम या 2 साल का प्रीमियम लेके इंश्योरेंस कंपनियां दिस काइंड ऑफ रन ऑफ कवर बेचती है, इस टाइप के रन ऑफ कवर बेचती है. तो प्रैक्टिस बंद करते समय हर डॉक्टर को रन ऑफ कवर खरीदना बेहद जरूरी है, so that you are protected against claims after you stop practice. This is a very dreadful name for many friends, many doctors. Errors and omissions insurance. Friends, errors and omission. Errors are acts of commission and omission are acts of omission. Both are components of negligence. Hence, errors and omission covers negligence or malpractice, medical malpractice. Hence, it is also called as malpractice insurance. Summarily, errors and omission insurance is same as professional liability insurance, is same as malpractice insurance, is same as indemnity insurance. So all the 4 terms in dark green color on the screen right now, they mean one and the same, which we popularly call an indemnity insurance. Now, what does the indemnity insurance cover and what it does not cover? So what it covers is green. So green is a yes and red is the no. So what does it cover? It covers professional negligence. Obviously, that is why we buy an indemnity policy. It covers loss of data or documents. Please understand, If the patient sues you for losing his data, then the indemnity policy can come to save you. Unintentional breach of confidentiality. Friends, here I would like to give you an example. The breach of, we are all tied in a contract of confidentiality with our patients, and you are not allowed to breach that contract. However, sometimes you may unintentionally breach this confidentiality. For this, again, I am using an example. I am very fond of using examples because I am an anesthesiologist. Again, this is an anesthesia practice example. You can extrapolate it to your clinical practice. You are called at Dr. Kamath's hospital for an MTP on Mrs. Rao, who happens to be the wife of your friend Vivek Rao, who stays and works abroad. Wife stays in your town, and Vivek stays abroad. MTP goes well, you ascertain the well-being of Mrs. Rao and depart from the hospital. A month later, you meet Vivek Rao at a Rotary Club dinner, and after exchanging pleasantries, you ask him, how is your wife doing? And Vivek asks you, oh, what's wrong with my wife? And then you say, oh, come on, what's wrong? Why do you mean by what's wrong? It's just a 1 month back. It's not even a month that I did an MTP on her. This disclosure, I want to ask all my friends who are listening to this video or listening to this webinar, how many of you feel that this kind of a loose statement before Vivek Rao is incorrect on the part of the anesthesiologist? How many of you feel? Believe me, this is an example of my own friend from Mumbai. The pregnancy of, the names have all been changed. The pregnancy of Mrs. Rao was a pregnancy out of wedlock. Mrs. Rao had faltered in a weak moment of loneliness. Vivek didn't know about it. Mrs. Rao loves her husband, wants to save her family. She wants to save her marriage. But your disclosure has brought a storm in the Rao household, and Mrs. Rao slaps you with a compensation claim for an intentional breach of confidentiality. Now, friends, my friend in Mumbai has indeed received a notice from a lady like this for an intentional breach of confidentiality. So in this court matter, the whole court case is fought on the singleton term or singleton concept of whether your disclosure was intentional or unintentional. But if you lose this case, provided it is proved in the court, and then if you win this case, provided it is proved in the court that your disclosure was unintentional, then the indemnity insurance can come to your rescue. But if it is intentional, it cannot. So the indemnity will not cover intentional breaches of confidentiality. Defamation, there are two components of defamation, and I hope everybody knows: libel and slander. Slander is spoken defamation, and libel is written or printed or published defamation. So even defamation is covered by indemnity insurance. If a defamation claim comes against you, it is covered by indemnity. Defense costs means the lawyer's fees, and out-of-court settlements. Friends, I will like to tell you, out-of-court settlements are very essential. Please go for policies which allow out-of-court settlements. Do you know that insurance companies don't allow out-of-court settlements? Why? What happens is that whenever a patient is very aggressive and the patient sues you in the court, slaps a court case on you, they are very energetic and very aggressive. They feel they will put you behind bars. So they go to the court. 4 years, 6 years, 7 years, 8 years, 10 years down the line, the patients start understanding that this is a losing battle. They have to go and go to the courts, and tariq pe tariq is the only fate of those cases. All the people who have pumped them into filing a case against you have all disappeared by those 10 at the end of those 10 years. Then through somebody, that patient sometimes sends you a feeler for a settlement, out-of-court settlement. In Mumbai, it is called Mandavali. In Maharashtra, it is called compromise. So an out-of-court settlement proposal, if it comes your way, every doctor will always want that this panauti should end, this problem should finish, this case should conclude. So you also might be keen on an out-of-court settlement. But do you know that your indemnity insurance company says no out-of-court settlement allowed? Let the case meet its logical conclusion, and if the court gives a compensation, we will pay it. Don't go for out-of-court settlement. Why they say this? Why do they say this, friends? Do you know? The answer is obvious. If they start giving out-of-court settlements, there will be a big crop of compromises. For example, Dr. Rajesh Kulkarni and me, I am friends. We are friends. I am a doctor. Rajesh Kulkarni is my patient. We both hobnob with each other. We scheme, and he files for a 20 lakh compensation against me. We both go, he goes to the court against me. After 10 years, we both file for compromise. If the insurance company allows us to compromise, we settle a compromise formula for 10 lakhs. Rajesh will take 5 lakhs, I will take 5 lakhs. Insurance company will be at loss. So the insurance company does not want this malpractice to start. Of course, all doctors are very sincere, very reputed and respectable, but this kind of black sheep also are likely to exist. Hence, insurance policies don't allow out-of-court settlements. But always be in the search of an insurance company which allows you out-of-court settlement. That is the best policy. What the indemnity insurance does not cover is criminal acts of frauds and violations of law. If you are delivering medical services under the influence of alcohol or drugs, then your acts will not be covered by the indemnity policy. Intentional damage of the patient's well-being is also not covered by the indemnity. Means willfully participating in a kidney racket and all that, not covered. And the loan liability of an insolvent doctor which cannot be compensated with indemnity. I hope you understand. You are not able to repay your bank loan and you say that your indemnity should pay the unpaid bank loan. That does not happen. Expenses covered by personal indemnity insurance are first, compensation awarded by the court, legal expenses on the lawyer. Third is interest liability on the compensation. Always compensation claim is made in 2024 and the case is settled in 2038, 14 years after that. So 14 years, the compensation was due when the patient sued you. So for 14 years, you have to pay the interest on that compensation. The interest liability of the compensation is also covered, should be covered by the indemnity policy. I am telling you what should be your demands from an indemnity policy. Out of court settlement possibility and supplementary expenses. Now, what are supplementary expenses? What are supplementary costs? If you have to go to Delhi from whichever town or city you are, because the case is standing in the Supreme Court or the National Consumer Disputes Redressal Commission, then you have to travel to Delhi. So the airfare to from your town to Delhi is sometimes covered by certain insurance policies, and also the hotel stay and average hotel fee or hotel accommodation charges are met by the insurance company. These two are supplementary costs paid by the insurance company. Friends, don't laugh at this. There will be some doctors who will say, I can always afford air travel to Delhi. I can always afford a hotel in Delhi. Believe me, friends, if a 10 crore indemnity insurance claim is made on you or a 2 crore indemnity insurance is made on you, you lose your zest for practice. You lose your interest in your patients. You start doing lesser work. You start going to lesser hospitals. Your income is likely to diminish. And at such times, any respite from any of these expenses is welcome for every doctor. We have this. I have a long experience of aggrieved doctors from our community. Hence, if any insurance company pays the supplementary cost, it's good. Take it. Now, I'm sure everybody here in this group knows that medical establishments also have an indemnity insurance. So the hospital where you go, that hospital also should have an indemnity policy. Now, I'll go fast. I will not go for the claims against hospital. Now, friends, this is a cow's picture I'm showing you. So I will use some Hindi words because in Maharashtra there is a very common saying. I will explain to you. This is an ideal cow. Everybody wants that his or her cow to be as ideal as this. Chote singo wali means atraumatic, small atraumatic horns. बहुत ज्यादा दूध देने वाली, कम आवाज करने वाली, लेस न्यूसेंस, कपिला नाम की शुभ्र धवल सफेद, गरीब, नाइव एंड क्वाइट गाय. So this kind of छोटे सिंगों वाली, बहुत दूध देने वाली, कम आवाज करने वाली, कपिला नाम की शुभ्र धवल गरीब गाय is only an अंधश्रद्धा. It's only fictitious. It is a myth. No such guy exists. This exists only in stories and mythology. Similarly, a professional indemnity which permits out-of-court settlement, foods, air travel bills, includes hotel stay, provides legal help, gives a good AOA, AOY ratio, good loss coverage, long tail coverage, cheap runoff cover, all these at a low premium is purely mythical and fictitious. ये सब मिलना practically नामुमकिन है. You cannot get all these in one policy. So go for a policy which fulfills as many out of these as possible and call it as an ideal policy. Terms beyond the scope of today's discussion is what is hold harmless or save harmless, and what is the difference between an indemnity and a guarantee. I will quickly touch upon how much indemnity insurance is good insurance. The determinants are following. What is your specialty? What is your area of practice? What class of patients you serve? You serve in the MID, in the industrial area where most of the people are workers or daily wage laborers, or you work in an upscale Banjara Hills in Hyderabad or Malabar Hill in Mumbai, where your patients are all high class. How many patients do you handle per annum? and what do you feel could be the maximum compensation claim you may face? Because a doctor who caters to workers will never face a claim of 10 crores. But a doctor who caters to the Bollywood tinsel town or to the movie stars and cine stars of your state, you're definitely going to face bombastic compensation claims. So these are all the determinants of how much your indemnity policy should be. Yet, as Dr. Rajesh said in the introduction of the topic, there are distinct consumer disputes redressal commission. Then there is state and then there is national. The Consumer Protection Act has been revamped or revised in 2019. Before 2019, the maximum limit of a district consumer court was 20 lakhs. A patient could sue a doctor for only for 20 lakhs in the district consumer court. Today, in 2019, the Consumer Protection Act has been altered, has been modified, and now a patient can sue you for 1 crore in your own district. So the patient does not have to travel outside the district also to sue you for 1 crore, which used to be 20 lakhs until 2019. So this is one. Now, if the patient wants to sue you for above 1 crore, then 1 crore to 10 crore, the patient cannot sue you in the district court. He has to go to the state consumer dispute court, consumer court. How much is the limit of the state consumer court? Up to 10 crores. And if the patient wants to sue you for anything above 10 crores, then the patient cannot sue in the district consumer court or the state consumer court. The patient has to go to the national consumer disputes court, because that court has a basic limit of more than 10 crores compensation. And one more irony, friends, I want to share with you. The consumer court's fee or court fee stat for a patient who wants to sue you is only maximum is 7,500, even for claims about 10 crore. It is 7,500. You know, this is a new level of consumerism. The government wants to promote consumerism. The government wants to appear to be in favor of consumers. This is a consumer movement in the country. Hence, the consumers are being favored in any which way possible. That is why the court fee has been reduced. It is becoming easier and easier to sue doctors, and that is why indemnity is becoming more and more popular and essential. My recommendation is indemnity insurance cover of 1 crore is the basic or the minimum cover, whatever be your specialty, whatever area you may be from. 1 crore is the minimum recommendation from my side. The commonly asked question which people ask me is, best insurance company kaun si hai? Which is the best insurance company? The answer, if I try to tell you company X is the best, it is a myth. There is no company which is best. Companies are here to earn profit. You have to negotiate with the company on all the terms that we spoke. Nose coverage, tail coverage, claims made, occurrence based, AOA AOY ratio, out of court settlement, supplementary expenses. You have to demand all this, and the company which gives you most of them is the best insurance company. I will end with the Sanskrit couplet. Chintaniya hi vipadam ada deva pratikriya nakupa khananam yuktam pradipte vandhina gruhe. I will explain to you what this means. Chintaniya hi vipadam. Chintaniya means to think. Vipada means a calamity. It is appropriate to think of a calamity before it strikes. Ada deva pratikriya is the correct reaction. Thinking of a calamity before it strikes is the appropriate reaction. Na kupa khananam yuktam. Na means no, kupa means well, khananam means digging, and yuktam means useful. It is not useful to dig a well. Na kupa khananam yuktam. Pradipte vandhina gruhe. Pradipte means there is illumination. Due to vandhi means fire, gruhe means house. So there is no use digging a well when your house has already caught fire. Thank you. I feel I have concluded, and I have tried to cover all the concepts, principles, and nuances of an indemnity policy. Thank you, and I rest my case. If there are any questions, I will stop sharing my screen now.
So excellent presentation, Dr. Nilesh. And the jargon that the insurance companies use to confuse us has been explained extremely well. And the pictures that you used were fantastic. I think the core concepts were very well explained by the pictures, and without pictures, it would be really difficult to understand for anyone. So the use of pictures was excellent. I think few take-home messages: minimum 1 crore insurance. Second is occurrence-based policy to be favored, very important. Third is that ask the insurance companies all the questions that you told us. Are you going to cover my nose, my tail? Are you going to give me the extras? All these things, I think anyone who is now going to buy an insurance next year or this year will definitely ask the insurance agent, and I think the insurance agent is going to be in for a surprise how these doctors know so much. There was one question, which is the best company for insurance, that you have already said that it is company X. But I have a question on this. So, for example, in health insurance, you have data available online saying that so many percent claims are settled. Although we know that settled doesn't mean it is paid. Settled has a different meaning in law. So, like this, is there a data available for insurance, indemnity insurance also?
No, there is no such data. In fact, there is a name which is circulating in all associations these days. It was with Foxy, it was with my own parent association, that is Indian Society of Anesthesia, that is Cover You. Cover You is a name which is circulating everywhere, but Cover You does not answer any of these questions. None of them have any track records, because of which, besides that, I'll tell you, health insurance, nobody feels ashamed of sharing details. But indemnity insurance, doctors have a huge taboo. They feel that telling about a case that I encountered, the problems I confronted, it is a shameful aspect, and I don't want to share it with anybody. I feel that we all should mature. And if I face an indemnity claim, somebody says I was an incompetent doctor, and that I have to go through a case to prove that I wasn't an incompetent doctor, this is no reason for hiding it. We should share this as much as possible. Only then there will be a data available as to how many times the insurance company was helpful, how many times it was notorious, how many times it was mischievous. Currently, the answer to your question is, we are very unfortunate. We don't have any such data. So any such data available on web or social media is absolute nonsense. They have no data, because when you ask them, give me one example of a doctor whom you have given an advocate, give me one example of a doctor where your company has given an out-of-court settlement, they say, yes, sir, we will come back to you, and they never come back to us because they have no examples to share with us. Sometimes they give us a very smart answer that for privacy, in favor of doctors' privacy, we will not share names with you. But I am of the firm opinion, those people who want to, the moment they give you, I will ask you a question. I am helped by an insurance company. They help me settle a claim. At the time of settling my claim, if they take my permission, doctor, can we share your example with the other doctors? Do you feel I have the gumption to say no? I have the guts to say no? The answer is yes. I will say yes. Give me the money. You share my name with anybody you want. Will I say that or no? So they can always seek permission from the doctor to share these examples. Maybe they can block the name or the specialty, and they can tell this to people, but they don't want to tell because they have no track record. It will be a long time before we will have a track record. We will have this kind of statistics.
Thank you. There are two more questions. What is your thoughts about IMA indemnity insurance, and would you prefer a government insurance or a private insurance?
I will prefer a private insurance because private insurance is more competitive. They want to sell more. They are constantly competing with their other private counterparts. Hence, they are better. Government schemes are not good because the figures that they are clinging on to even now are medieval period. It is like, in CGHS, they say that an X-ray can be funded 60 rupees. Now, plumber or a carpenter also does not come in 60 rupees today, but CGHS is still paying 70 rupees for an X-ray or 60 rupees for an X-ray. Similarly, their insurance companies are also still clinging to very poor fees. For example, they say that the maximum ambulance expenses that their New India Assurance pays is 5,000 rupees. Here, the situation is that from a taluka place, if a patient is required to be taken by a cardiac ambulance to Hyderabad, to Chennai, or to Mumbai, I mean the top city in the state, then it can be anything up to 50,000 rupees also the cardiac ambulance can cost. So why should I go to an insurance company who believes that ambulance should not cost more than 5,000 rupees? The one reason why I will say don't go for a government policy is these reasons. Private companies are better, and the private companies are open. They tell you everything about their policy if you ask them questions. So best is to go to a private company. Was there any other sub question? No.
IMA indemnity insurance.
IMA. Now, IMA is a reasonably good policy. It is well negotiated. But one thing I will tell you, whenever the premium is dramatically low, start suspecting the policy. I will ask you a question that if I am giving you A, B, and C in 100 rupees, and I am giving you A, B, C, D, E, F, G, H, I in 25 rupees. Will you believe me? The answer is, if you want a nose cover, you want a long tail cover, you want supplementary expenses, it is going to cost. If you want everything to be covered, the policy is going to be expensive. So my first request with folded hands to all the people listening to me is stop getting lured by low premium. So please dump the attraction for a low premium. In fact, whenever they tell you everything is available and still the premium is low, start suspecting them. Ask them for a previous track record, because we will buy a policy. What I have heard is that IMA offers a 500 rupees policy, 500 rupees indemnity policy. Friends, today 500 rupees is not the cost of a carpenter or a plumber who comes to your place, electrician who comes to your place. How can a doctor be protected against negligence claims in 500 rupees? So start suspecting it and don't cling on to low premium. So IMA policy can be good, Foxy policy can be good, Cover You can be good. Ask questions, satisfy yourself that all these aspects are going to be covered, and then only believe it.
Correct. So there is one more question. Suppose somebody is working in an institute, maybe a government institute or a private institute, and somebody junior to you has has made some malpractice or something happens, some incident happens. So will your policy cover you in that case?
If you have been made a party in the case and the court awards a compensation against you, the insurance company has to bear the cost of compensation. Okay. You can always, this is called vicarious responsibility, and vicarious responsibility is also covered by indemnity insurance. The issue is that you can always fight the case tooth and nail in the end, till the end, and if you are still made a party by the court, then the insurance company will have to pay them.
Will have to pay. Okay, there is one more question. What is umbrella insurance? What is umbrella insurance? I didn't get the question.
Yeah, I'll tell you what probably this umbrella insurance means. There are insurance companies which say you come to us and we will give you indemnity, we will give you car, we will give you life, we will give you general, we will give you home insurance, and we will give you everything. These kind of companies are umbrella insurance policies. There is no umbrella insurance in indemnity. There is no term scientifically explainable under indemnity called umbrella.
I think these are the main questions that I could read on the chat box. Ajay Kumar sir or Srinivas sir, any questions from any of the other seniors here? Sri Krishna sir, Ajay Kumar sir.
I will still tell everybody that this is a good idea to reach a lot many people. Webinars were born in the COVID era and they are still a viable option. But there is nothing like having a personal one-to-one physical CME or conference in which we talk, because there are a lot many solutions I can offer and discussions that can happen when you are personally present.
One more question. Do doctors working in government service come under consumer court cases?
Yes, they do. Yes, they do.
So the government doctors need to ask their institute or whatever organization they are working in, what kind of insurance cover they have. Because they may have a cover of 5 lakh or 10 lakh and the claim is made for 1 crore. They are not going to pay the rest of the amount.
Yes.
So I think it is important.
Yeah, most importantly, there have been debates as to where free medical services, totally free medical services are available. Some courts have struck down claims because certain government hospitals are totally free, not a penny is paid by the patient. But 95% of the government hospitals, there is 5 rupiah for a basic paper at least. The moment some money is collected, you are all covered under consumer protection.
Excellent. I think we have probably got answers to many of our questions, most of our questions. And it was a delightful, wonderful talk. And I think doctors are more empowered now to really ask questions to the insurance agents who try to sell them policies. I am very thankful to Ajay Kumar sir and Pawan Kalyan sir for giving this opportunity to me to moderate the session. And thank you, Dr. Nilesh, very wholeheartedly. We thank you for clearing all the concepts. Thank you very much.
Thank you. Thanks a lot. Thank you for calling me. And it was a wonderful experience. I still feel that I am so unhappy because there are so many learned men. I can read their names, but I can't see what they feel about the talk, whether they are in agreement with me or what. So webinars are good, but I still feel that if ever anybody desires, you should invite me for a personal talk in a conference or a CME. That will give fantastic results.
1:1 interaction, really.
Yes.
Thank you very much, sir. Thank
Thank
you.
you. Thank you. Thank you.
We can end the meeting.
Can I leave now? Yes.
Yes, sir. Thank you.